this webinar. We really appreciate their involvement, and so we're going to get going. I'm going to just have a quick chat about the privacy slide here, standard privacy slide. So please keep any of your questions generic as possible. Don't identify individuals. We do want to make sure that we protect the privacy of individuals and the corporation itself. So otherwise, I'm going to turn it over to Jennifer. Go ahead.
Okay, thanks, Daryl. It's my pleasure to be here. I really think very highly of CHOA and the amazing contribution to education that they make. I also wanted to share with you that today is the 22-year anniversary of my call to the bar in British Columbia. So I've been doing this a long time. I love Strata, and what I really like about Strata law is I like to lend order to chaos. I'm a solicitor, and that's what I think I do mostly. So I also have a passion for sustainability issues, and that's probably why you've seen me speak on heat pumps and EVs and those sorts of things before. Heat pumps are a hot topic, no pun intended, of course, but I'm happy to be here to chat about it. So let's talk about, and Daryl's got the slide up already, accessibility and fundamentals. So a couple of months ago, Tony mentioned to me that he was aware that there's a trend in the industry that managers and strata councils are automatically assuming that heat pumps are automatically permitted under human rights legislation. So I agree human rights legislation is a factor, but we need to start at the beginning. And I would encourage everybody to remember that it's not an automatic permission for a heat pump. So the purpose of human rights legislation is detailed in the Biggins and Park decision that's up on the slide right now. So the goal of human rights legislation is transformative. It's intended to foster an equitable society. Likewise, accommodation is the process of fine-tuning society so that its structures and assumptions do not result in the relegation and banishment of disabled persons from participation, which results in discrimination against them. So in other words, if all strata corporations were to discriminate, there wouldn't be anywhere for people who have disabilities to reside. Next slide. So the Human Rights Code applies to strata corporations, and we know that because of Section 8 of the Human Rights Code, which says that you can't deny accommodations based on Indigenous identity, race, color, ancestry, place of origin, religion, marital status, family status, physical or mental disability, sex, sexual orientation, gender identity or expression, or age. And I'm not going to read those out again, but those are all of the issues that are covered by the Human Rights Code. Next slide. All right, Section 121 of the Strata Property Act says that a bylaw is not enforceable to the extent that it contravenes the Human Rights Code. And that can be relevant to heat pumps. So I'll give an example. In the old days, back 20 years ago when I was drafting bylaws, that was pre climate change issues. Well, I guess climate change was around, but it wasn't as relevant as it is currently today. I would say 90% of the bylaws that I drafted said no owner will use or install an air conditioner or other heating or cooling unit, period. So nobody was getting them. Nobody had the right to get them. But under the Human Rights Code, that may not be enforceable. And it's really just dependent on the person who's arguing that they have accommodation. So for example, the bylaw that says you can't have an air conditioner. Well, if I had a heart condition, would the Strata Council be able to prevent me from having from installing air conditioning? I think that would be something that we would want to consider. And most lawyers are going to love to say it depends. I'm sorry that we do that, but it's always dependent on factors, of course. I'm not trying to be a jerk. It's just the facts are important. So this talk is really intended to give us the tools to navigate how to deal with human rights issues related to heat pumps. Next slide, please.
Yep.
Oh, yeah, perfect. Thank you. So fundamentals of accessibility. The Human Rights Code applies to bylaws and rules. So does that mean you can't have a bylaw that prohibits heat pumps or air conditioners? No, it doesn't. But it means the council may have a duty to accommodate a disability. The Human Rights Code applies to decisions of the Strata Corporation either by the council or when the owners collectively make a decision at a general meeting. But so does that mean the council can never deny a heat pump? No, it means the council has to accommodate a disability. So when application for cooling or heat pump is submitted, you have to consider the implications of those decisions. Next slide, please. What does discrimination look like? So Section 8 of the code sets out all of those classes of persons that are entitled to be protected. Like I said, I won't read them again, but take a look at Section 8. Let's go to the next slide. Okay, so if I was in a room with people, I would ask you to put up your hands, and I kind of miss those days when we're all in the same room together. Um, the question, can you have a bylaw that prohibits air conditioners or heat pumps? So here's an example of a bylaw. Air conditioners that are inserted into windows, ventilated through window systems, or visible from the outside of the building are prohibited. In my opinion, that's an okay bylaw. But just as an aside, when I draft bylaws, I really like to use I don't like to use passive language. So I would draft it as no owner, tenant, or occupant will install windows ventilated through window system, et cetera, et cetera. So the Strata Corporation, in my opinion, can have this bylaw, but it's not always going to be enforceable. Next slide. Okay, so in this case, the bylaw is neutral on its face. So it doesn't automatically pick on a person for having a heart condition. For example, it doesn't say if you, well, we don't even have to say heart condition. For, as a person who can't walk or can't move, we're not going to have a bylaw that says you can't move around, but we may have a bylaw that picks on a person based on the bylaw, not on its face, but the way it's implemented. So when it's applied to a person, it may be discrimination. Okay, next slide. So let's look at establishing discrimination. First, the person has to show that they've been denied an accommodation. And then second, they have to show that they're a member of the class of protected persons. So that list of all the people that I read out at the beginning, that's Section 8 of the Human Rights Code. In most cases, owners who are asking for accommodation are suffering from a disability. So it's not sex or sexual orientation or gender. It's mostly disability. That's the person has to prove that they have the disability. And the way to do that is using the form of a doctor's letter. It's usually easy to prove that they have a disability. And so not many human rights cases actually turn on the question of whether there is a disability. What needs to be put in the letter from the doctor, it doesn't say, it shouldn't say it would be beneficial. It should say the accommodation is medically necessary. So that's the test. So the complainant has to show that they've had differential treatment, so that the disability was a factor in the way they were treated, and that the way they were treated was actually related to their discrimination. Moving on to accommodating a disability, Strata Corporation has the duty to accommodate disability. So we're on the accommodating a disability slide now.
Oh, okay. There you go.
Oh, perfect. Thank you. Okay. So there was a decision in the Human Rights Tribunal years ago, and I might not pronounce this correctly, but I think I am, Konezka. And in that case, the Strata Corporation had a bylaw which prohibited hardwood floors. We couldn't understand why that would have been the case. So obviously they're worried about noise. On its face, it was a neutral bylaw. So it didn't specifically target any of the persons who are deserving of accommodation. But in this case, the owner had allergies. So that was a disability. And the Strata Corporation had to accommodate the owner with the allergies by permitting her to have hardwood flooring, even though the bylaw prohibited hardwood floors. So moving over to the next slide, let's look at the 3 factors that are to be considered. One, was the bylaw reasonably necessary? Yes, it was, because it was to prevent noise transference. Two, was it done in good faith? Yes, again, they were probably attempting to prevent noise transference. But here's where it gets more controversial. The Strata Corporation can't meet its goal and accommodate the person without incurring undue hardship, and that's where the question really comes about. Um, in this case, the tribunal determined that it wouldn't be undue hardship for the Strata Corporation to allow the owner to install their hardwood flooring. Um, there's another decision of the HRT as well called Holloway Chuck. That's NW 332. In this case, the Strata Corporation argued that the cost to install a ramp for a disabled person constituted undue hardship. And the Strata Corporation failed to show that there was undue hardship, and they were ordered to construct a wheelchair ramp. Now, that actually brings us to another case, which was in 2022, and that's a decision that is a bit more flummoxing to some lawyers and some people. It's the Testar decision, and that's Testar and VR 1097. It was a very unique strata corporation. It had a hillside where there was one strata lot that was at the bottom of the hill, and the owner was aging, and I think he was in his 80s, and he argued that he required a tram to be built by the Strata Corporation so that he could access his Strata Corporation, which was at the bottom of the hill. It was about $150,000 to pay for the tram, and the order was that yes, the Strata Corporation was obligated to contribute to those costs. But in addition to that, they ordered damages in favor of the owner of $35,000. So it's really important for strata corporations to understand first that they have a duty to accommodate a disability and to take steps to be reasonable as to how they're going to deal with it. I'm not sure if Mr. Testar was open to different ways to accommodate, but it's possible that they could have found a way that didn't involve almost $200,000 worth of cost for the Strata Corporation. So, so in a scenario where an owner is arguing that they are entitled to accommodation when it comes to a heat pump, I think you'd be hard pressed to argue that the Strata Corporation ever has a duty to pay to install a heat pump. But I think that it would be easy enough to say that the accommodation would involve permitting an owner to pay the cost to install their own heat pump, even if there's a bylaw that exists that says no heat pumps.
Would it
So
also
another
be, sorry, Jennifer, just really quickly, would it also be something the strata could ask the owner to remove it when they leave or if they're no longer an owner?
Yeah, I've seen a number of different approaches to that. And so sometimes strata corporations will ask for an alteration and indemnity agreement and will specifically ask that if they sell, they'll take it out. That's a great way to do it. I've also seen, and the CRT supports this as well, I've seen scenarios where strata corporations have allowed owners to install not heat pumps, but to have a portable air conditioning system. And there was a CRT decision that said that that's sufficient to address a disability.
Right.
Yeah. So another example that I like to think about when it comes to accommodation, and this came up years ago. I was working with the Strata Corporation, and there was an owner who was arguing that they needed a dog to deal with their anxiety. But the question was, it was a large dog that they had. I think it was a German Shepherd. Did they need the German Shepherd, or would a beagle have done? So it's always strata corporations always have the ability to try to show some flexibility when it comes to accommodation, and there isn't one specific right thing. I also worked with an owner last year, and she had a heart issue, and so her doctor had said she needed a heat pump. But she also felt that she was entitled to have the Strata Corporation pay for the cost to put on a different colored roof because the belief was that the color of the roof was creating too much heat in her unit. So I was able to convince her, yes, let's go for the heat pump, but let's not go for the costly roof redo. And I think I was right in that scenario. So Yes. So we are on who must be accommodated. Okay, and we've got a quote here from the HRT. If strata corporations were able to avoid making buildings and facilities accessible on the basis that the owner should not have bought in the building in the first place, individuals with disabilities would be banished to have very specific and limited housing. And I think that really just shows the spirit of the Human Rights Tribunal there. Next on to common requests. This one, accommodation, we've got heat pumps here in red because that's the that's what we're here to talk about today. So we see a lot of other requests regarding accommodation. I talked briefly about hardwood floors, and I talked a little bit about ramps as well, but heat pumps are our thing today. Okay, so where do we start? We've got a list of questions here. Does our strata corporation have a bylaw that applies to air conditioners or heat pumps? And I would say this is what the council is asking itself. If it doesn't have one, I would say you definitely should have one. I did an article for the Choa Journal. I think it was actually almost 2 years ago now. I think it was December 2022, if I recall correctly. It's still valid, and I think it might be something if you're in a strata corporation or if you're on council and you don't have a specific bylaw regarding air conditioners or heat pumps, it's a good first start to figure out what you might want to have in that bylaw. And the next question the council is going to ask is what property is being altered? Is it a strata lot? Is it common property? Is it limited common property? There are so many variations with all of these types of alterations. And again, if I was in person with all of you, I'd say raise your hand if you knew whether a heat pump involves limited common property or common property. I can't do that, but what I'm going to tell you is it's quite varied because many heat pumps have a split system, and that's going to have an interior component and an exterior component. So it probably involves the strata lot, but it's also going to involve the exterior, which may be common property. It may be limited common property. It could even be part of the strata lot, depending on how the developer set it up in the first place. My experience has been that many strata corporations that were developed in the 80s have the patios and balconies as part of the strata lot. And I think it was just a trend that the developers were doing at the time. So the next question is this an accommodation request under the BC Human Rights Code? And it's up to the person to identify whether they have a disability. I worked with a strata corporation recently, and there was a rumor that the person may have required accommodation, but the person hadn't actually given any evidence of that. And I just said to them, just wait for the person to provide some evidence so that you can assess it. But it's not up to the strata council to go and investigate and find that evidence. And the next question is it a significant change in the use or appearance of the common property or of a strata lot? If it's a significant change in the use or appearance of common property, it may involve a three-quarter vote under Section 71 of the Strata Property Act, depending on the circumstances. And
And
finally, the question is, has the Strata Corporation completed an electrical planning report yet? I just wanted to give you the reminder that there is a deadline that's quickly approaching, really, December 31st, 2026, and that's for the Capital Regional District, the Fraser Valley Regional District, the Metro Vancouver Regional District. That's December 31st, 2026. And then for all other areas, it's December 31st, 2028. So I think we've done a number of different topics for CHOA on the electrical planning report. And I also did prepare a handout which talks about why strata corporations should get on that as soon as they can. It's beneficial in addition to complying with the law.
so Jennifer, real quickly, back to item 5 here. Will it require a three-quarter vote approval of it at a general meeting? What happens if the accommodation is required, but the owners defeat the three-quarter vote resolution?
Oh, that's a good question. So, if when you say it's required, presumably you mean it's necessary to
Necessary.
accommodate a disability. Um, so what I would, if I was representing the Strata Corporation, I would say get it back to another meeting and explain to owners why it's necessary to accommodate and what the implications would be if the Strata Corporation fails to permit it. Um, the other thing to keep in mind is there are a number of different ways to accommodate. So it's possible in the scenario that you're mentioning, maybe the reason that the owners declined to approve it was because they didn't like something about the color or the style, and maybe there's another way to convince the owners that we can shift it so we can still accommodate the person and satisfy the color and the style that you're looking
Right.
for. Yeah.
Thank you.
Yeah, now the other thing to keep in mind is that in many of these alterations, the owners are volunteering to pay for the cost. For example, heat pumps, my experience has been owners always pay for the cost of heat pumps. Um, a number of years ago, actually, I worked with a strata corporation, and they had there was one owner who had a young child. I think she was 10. She was quite severely disabled, and the strata corporation, the owners really wanted to um, alter their patio so that it would the windows would open up, and the child with the large wheelchair could just roll into the unit. So good reason that the strata corporation that the owners wanted to be able to do that. It was a huge departure, and it was a difficult change because it was going to change the way the strata corporation looked, the look of the buildings. Um, at any rate, what we agreed upon, as you mentioned, Daryl, one of the things was that when they moved, they were going to put it back to the way it was, and they were going to pay for everything. And so I explained to the strata corporation that the owners actually didn't have an obligation to volunteer to pay for all of those costs. And it was quite a cordial discussion between the owners. In my opinion, it was quite a good result. Now, I've diverged a little bit from what I was talking about, but I kind of like to tell stories because I think it's interesting. Should we move on
Yeah.
to heat pumps limitations? Okay, so standard bylaw 6 says that an owner has to obtain written approval to alter common property. So it doesn't prevent the strata corporation from unreasonably withholding approval when it comes to common property. But there are some CRT decisions that say that the strata corporation has to be reasonable. So in other words, with respect to both the standard bylaws regarding whether you can alter common property or whether you can alter a strata lot, to my way of thinking, strata corporation should always be reasonable. That's how you stay out of trouble. So I don't think it's hard to be reasonable either. Now, alteration agreements, in my opinion, are fundamental to allowing for alterations. You should have a bylaw that says that an owner who is getting approval of an alteration is required to sign an alteration and indemnity agreement. Now, the standard bylaws they sort of allude to the idea that they might agree to terms, but the bylaws that I draft specifically say as a condition of approval, the owner is going to sign that alteration and indemnity agreement. And that applies to heat pumps. It also applies to and should apply to electric vehicles, which is, I guess, my other passion for sustainability. Um, now, what I like to see with the alteration agreement, it should address things like permits, legal costs, future repairs, but that make it binding on a future owner. And in my opinion, having a good template for the Strata Corporation is money well spent. Um, I think I gave a similar presentation about 2 years ago in December. I talked about alterations, and I gave the same opinion. I got calls from quite a number of the attendees, and I just said, put the template in place. I think I charged about probably 500 to 600 for the template. I sent it in a Word version so that the Strata Council could manipulate and use it as they needed to. My opinion is just money well spent to have something like that. Now, council should make sure they also consider all factors, including the electrical services and the impact on other owners. Um, that's why I think it's wise for strata corporations, if they haven't already gotten their electrical planning report, it's time. Even if the deadline hasn't come about, if you don't have enough capacity, you probably want to anticipate that now while you're approving the early heat pumps rather than later.
Mhm. So we had these questions have come up before and things, but say, for example, the Strata Corporation has given a few people the opportunity to have heat pumps, but they're now at the capacity of the electrical system and they have an accommodation request to deal with. Any idea of how to deal with that?
I guess there are a couple of options. And the first option is determining whether there is another mechanism by which the person could be accommodated. So maybe a heat pump doesn't work at this time, but maybe a portable air conditioner in the short term
Right.
works. And I think getting the electrical planning report is so important because it's going to have different mechanisms and suggestions for how to take advantage of the capacity that they already have, which may, for example, and I know you know more about this than I do, Daryl, but changing out light bulbs and things like that, that may free up more capacity for heat pumps. So having that planning report is important. But at the end of
Yeah.
the day, though, if there's not enough capacity and it can't be obtained in any other way, the Strata Corporation still has the duty to accommodate, and the electrical planning report may suggest mechanisms to expand the capacity. And
Hmm.
that is something, especially based on the Testar decision that I was talking about earlier with the tram. I think that's something that's the Strata Corporation would have to pay for.
Right.
So you know, talked early in this discussion about how I like to lend order to chaos. I think planners really can avoid chaos, and I know that with CHOA, there's so many councils, and I'm sure there's some on this call right now who are here because they want to learn and they want to plan and they want to protect everybody in the Strata Corporation. Those are the Strata Corporations that I love to work with best,
Mhm.
if I have to pick favorites.
Super. Yeah, and I guess the idea here is that, when you look at that decision with the tram involved, that the barrier is quite high. Like the Strata Corporation's obligation is very high. It has to do what's necessary to accommodate, even when it comes to hundreds of thousands of dollars worth of work sometimes,
Yeah.
depending on the situation, right?
Yeah, I actually, in my early days as a lawyer, I lived in a strata corporation. It was about, I think it was 27 owners, and it was a townhouse style. And I remember when my husband and I were looking at moving in, uh, I, we were looking around the property, and I pointed to the wheelchair ramp, and it was like a crooked, cracked, off center sort of. It wasn't a ramp. Like, we used to ride our bikes down it and enjoy that. But I remember saying to my husband, if anyone ever buys into this strata corporation and has a disability, we're going to be on the hook to make that ramp appropriate. So that's just yeah, that's just part of the planning that has to go in uh, for strata corporations.
Thanks.
Now I'm on managing a heat pump request.
Okay.
Okay, terrific. So I already mentioned this. I'm going to say it again because I think it's so important. I strongly recommend that the Strata Corporation have a detailed bylaw, and that's going to encourage consistent treatment of owners, and it's also going to ensure that owners understand what's required. So I'm going to refer to that Winter 2022 CHOA Journal article, sort of setting out all of the kinds of things that you want to see in a bylaw like that. It also makes sure that owners understand what they can and can't have. I was working with the Strata Corporation recently, and there was an owner who had just moved into the building, and the owner was saying, "We have a baby, and it's hot out, and we need to protect the baby." And I completely agree with that. But what the owner was also saying was that they wanted to install this heat pump that was going to be drilling into the building envelope, and it was the only way to protect the baby. And when I got involved, we clarified, and I referred to a couple of CRT decisions. We verified that no, that's not the only way to protect the baby. It may be your desired means to protect the baby, but there are other ways. I also, and this is a cautionary tale, I was working with the Strata Corporation last summer, and the council approved a heat pump, and they had a very detailed scope of work, and they did what I would recommend. They attached the scope of work to the alteration agreement, so it was really clear what the person was permitted to do and not permitted to do. But the problem with this particular council, they did many things right, but what they did wrong was they didn't actually look at the scope of work, and they didn't actually put their minds to how it was going to be set up. And so after the a heat pump was approved, there were a number of owners who complained because the heat pump was visible on the side of the building. And the council took some grief from complaining owners, and they decided to change their mind and try to withdraw approval. Um, but you really can't. You've got a written agreement confirming approval. They lost at the CRT recently because you can't do that. So my advice is, and I know there are council members on this call listening, when you're doing when you're making decisions, make sure you're actually looking carefully at what you're doing, and don't sign anything until you really know what you're agreeing to. If you have questions, make sure you get the answers before you sign. I guess maybe I learned that in my first day at law school.
Always good advice.
Yeah. Yeah. So on to the next slide. Leary and Strataplan VR 1001. This just talks about the process to evaluate as set out in the Leary test. I don't think it's uh, specifically related to heat pumps. And I think also I've talked about a lot of it already. So I think we'll just move to the next slide
Sure.
about the person seeking the accommodation. So what the person seeking the accommodation has to do, they have to advise of the disability and they have to provide information. But I think the other thing we want to think about is how the Strata Corporation is going to be storing that information, because it's going to have a component of it that's confidential. So the Strata Corporation is going to want to make, or the council in particular is going to want to make sure they're protecting it. I recently saw a situation, a past council member still had access, they had everything online, and a past council member still had access to, for some reason, the online documents and was using them in a way that wasn't, of course, related to their role as a council member. So I'm sure there are multiple CHOA presentations on this as well, but lock down the information, make sure it's protected. Okay, so next slide. Yeah, so the person seeking the accommodation has to cooperate with the strata to provide evidence to meet the goals and prove that the accommodation is medically necessary. So again, I use that phrase medically necessary because that's what the case law says it has to be. So I regularly see letters, and I don't want to pick on dog lovers, but I regularly see letters from doctors that say it would be so beneficial for this person to have a dog, and I love dogs too. I have two. I agree that they're beneficial, but it's not medically necessary. It's just beneficial. So that's the test that you want to think about. Um, Now, next slide. So the person seeking the accommodation has to cooperate with the Strata Corporation and discuss possible solutions. As I mentioned, it's important to remember that accommodation can come in a number of different ways. So the person seeking the accommodation isn't entitled to the perfect accommodation, but to one that reasonably addresses their needs and upholds their dignity in their housing. Um, and accommodation discussions require both parties to participate. All right. So the person seeking the accommodation must cooperate with professionals or other parties who have to be involved to explore accommodation solutions. So there might be a scenario. I guess my scenario with the roof, the person who wanted the roof to be changed, there could be a possibility where the roofing company could have been consulted to provide an advice as to whether the color of the roof actually would have impacted the heat and the temperature in the stratolot. I didn't, in my own opinion, that wasn't necessary for accommodation purposes, and we went past that. So the council must address requests for accommodation promptly and take them seriously. Strata corporations should consider how it will process accommodation requests on a timely basis. So there are some really proactive strata councils that will have people appointed on the council for dealing with these kinds of things. There are some strata corporations which have just one person who deals with everything, the president or whomever it was. And that's strata councils can set themselves up as they want to, but it's important to make sure that the requests are dealt with promptly and taken seriously. Okay, so the council must gather information. Again, medical information is required. Be careful to protect that information. Also, next slide, the council must restrict access to the person's medical information. We talked about that already. Keep it confidential. If approval is granted because of a disability, the minutes, in my opinion, should be very clear, but not specific. And so, for example, don't say, Jennifer has a heart condition, so she gets to have a heat pump. That's too much. And it's going to make other owners what we want to do is make sure that the minutes enable other owners to know that they have to comply. So I'm going to read it out again, and I'm going to read it in a way that I think is helpful. So the minute should say something like, the council has approved the installation of a heat pump in Strata Lot 1. Although bylaw 5 prohibits heat pumps, the owner has given evidence that the heat pump is medically necessary. The Strata Corporation has granted approval on account of the Strata Corporation's duty to accommodate under the Human Rights Code. And so the purpose for doing that really is to make sure that other owners understand that they're not entitled to the same accommodation unless they jump through the same hoops. Okay, so council must, it says must, but they may obtain expert opinions or advice where needed. There may not be a need for expert advice. It really depends on the scenario. Next one, the council must take the lead role in investigating possible solutions. So the bottom line is the council should be cooperating with the person seeking accommodation. In law, part of what I love about my job is, we're getting to yes. We're finding ways, and we're trying to find ways to get to the right solution for everybody. There are, as I mentioned, different possibilities. And for example, the CRT has said that is not always going to be heat pump. Sometimes it's just going to be a portable air conditioner.
Right. Not the Cadillac when the Pinto will do.
Oh, who doesn't like a Pinto? I I think I learned about that in law school too. That was the
Yes.
one that blew up, right?
Yeah.
Yeah. Pinto will not do. So I wanted to go now to the Civil Resolution Tribunal
Sure.
decisions. Next slide. Um, so throughout the presentation, I've been asking, does the Strata Corporation always have to give approval for a heat pump? Because you might recall at the beginning of the session, I had said that Tony had heard through the grapevine that there were strata managers who were giving the advice that a Strata Corporation always has to grant approval for a heat pump because of human rights. And again, if I was in the room with all of you, I would ask you to raise your hand and tell me whether you agree with that. But I'm just going to tell you, Strata Corporation does not always have to grant approval. A person with a disability is going to have to prove that they have a right to an accommodation. So the Kwan decision, that was a CRT decision where the Strata Corporation, and it's on the slide in case anyone's interested, the CRT said a portable air conditioner was enough to provide the same benefit. So in that case, the owner was insisting that they were entitled to a heat pump, and the CRT said, no, portable air conditioner works just the same way. So the next slide, I just wanted to reiterate again, take a look at that CHOA Journal article because it does set out some recommended bylaws in there if you don't already have a bylaw. And I also wanted to identify this Rasmussen case, which is also discussed in the article. But I actually really like this case. I think it's a good decision, but it's also very clear as far as the Strata Corporation's, the council's duties with being met with a request. So in Rasmussen, the owner argued that the Strata Council's delay in approving the request for a heat pump was unreasonable. And the CRT said, no, the council had already taken steps to carefully consider putting a bylaw in place. They had a plan in place, and the Strata Council was entitled to continue doing that. So Mr. Rasmussen didn't get an automatic order that he was entitled to install his heat pump. And so bottom line is, if you're on a council and if there's currently no bylaw on heat pumps, I would suggest it's time to get a bylaw in place right away. Now, either that bylaw is going to say no heat pumps or no air conditioners, or it's going to say you have to get approval for a heat pump, and these are the conditions under which approval would be provided. Um, Now, if the Strata Corporation is in a situation where it doesn't have its electrical planning report, it doesn't have any information at all on whether it has the capacity to allow heat pumps, it may be that the first step for the Strata Corporation is to say no heat pumps and no air conditioners, get the electrical planning report, and then put in a better plan for future. Because I think the writing is on the wall here. We're going to see, especially with heat in BC rising every summer, we're going to see there will be a time where the CRT is going to say, Strata Corporation, you delayed too long. This owner has the right to install their heat pump.
Yeah, we've got some questions about timeliness of responses, but I think a good question that Tony brought up was, should we have legislative changes to approve or make it easier to approve these types of things? Do you think that would be worthy?
Well, I don't know what the legislation would say at this point because every strata corporation is so different. So if you just had legislation that said you can always have heat pump, that that could be disastrous for some strata corporations. But I guess we saw that a little bit with electric vehicles a couple of years ago. And in my view, and I've presented on this as well, I think it was a pretty reasoned approach for the strata for the BC government to take. I don't know if there's any impetus for them to start thinking about heat pumps, but
Right.
it might be a good idea. Yeah.
Say lowered the barriers on approval, but still required it. Yeah.
Yeah.
Yeah. That's interesting. Okay, thanks.
Okay, so I'm on now. My last slide is how does the council consider a request?
Yep.
Okay, so first, look at the bylaws closely. What can an owner do or not do? Now, I've worked with some councils that haven't looked at their bylaws and forever, and they may be saying, "Oh, it's always been done this way or been done that way." It's important to look at the bylaws, and if you don't, as a council, have a copy of the bylaws, get the property manager to get them for you, pull them from the land title office, or call me. I'll get them from the land title office for you. If they're old and they're outdated, it may be time to update them. I think it was the December a couple of years ago. I did a similar presentation on heat pumps, and out of that seminar, I probably had 10 or 12 strata corporations call me to put a heat pump bylaw in place, and I feel proud of that because I think that they probably avoided disputes with owners over that. So because I think the value of having a bylaw in place is that you prevent owners from saying that they're allowed to have crazy things. They're allowed to, reach the building envelope, for example. This council has the ability to have a very reasoned approach to what they want to permit. And then
Mhm.
everybody knows what's permitted or not.
So just to help you here, bulletin, the article you're talking about is a bulletin that's going to get posted on our YouTube channel with this webinar.
Oh,
And it's
great. Okay.
bulletin 200-270. So there
Okay.
you go.
Terrific. Thank you. Now, the other thing we want to look at is we want to take a look at the property, review how the property is held. As I mentioned, many heat pumps have this split, are split, and so it could impact the strata lot as well as the exterior. Who knows what the exterior is? You want to look at the strata plan. Um, and you also want to look at technical information. So does this work? You may need to get an opinion from an engineer or electrician. I've seen many bylaws and drafted some myself where that's a condition for the owner to receive approval from the council for the installation of a heat pump. And I've also seen it done that Strata Council requires an opinion letter from an engineer after the installation. So an opinion letter is going to set out that it's safe, et cetera. And it might set out that, depending on the structure of the strata corporation, it might set out that the building envelope was protected, which is, of course, such an important aspect for strata corporations, new and old.
Yeah,
Um,
we've seen some strata corporations that have actually paid to have an engineer build a wall penetration system that has to be used in certain certain situations when the penetration's happening. So
Yeah, especially for strata corporations. And I remember when I started as a lawyer, that was around the leaky condo era.
yeah,
Um, People were spending their whole life savings on getting the envelopes put in. So you want to take steps to protect it. So yeah, having experts involved is a really good idea. Now, I think we have some time for questions,
yeah,
but I just wanted to say in closing for my remarks, every strata corporation is different. So always want to review the strata plan.
absolutely. And like I say, if we don't get to anyone's questions, which we're going to get to right now, please feel free just to send them in. Um, right from the beginning here, we had a few questions. One of them was about what are the ramifications of just blanket saying no? Like, no, you're not allowed to install it. Because I think we've spent a lot of time talking about the accommodation portion here, but we also have uh, savings and efficiencies and creating capacity in electrical systems. Say your electric heat based type unit, and you now got an air pump, which may be more, or heat pump, which may be more efficient.
Mhm.
And so you can create capacity that way. I mean, there's got to be some positive aspects of allowing this to happen beyond just I like having a cool place in the summertime.
Right. Yeah. So I'll tell you, I prefer to work with strata corporations where the council is being proactive and anticipating these kinds of issues. But I also work with other councils that are, digging their heels in. And I think the concern that I have about those heel diggers is that the CRT, in my opinion, is moving towards or has perhaps already moved towards an argument that the strata council has to act reasonably. So there was actually a decision on electric vehicles that came out, and I wrote an article on for the journal on this as well, which I think is the next article that will be in the next journal. But Strata Council has to act reasonably, and the CRT keeps saying that over and over again. So at some point, the question was, can you always just say no? I think at some point they're not going to be able to say no. And it may be a Rasmussen situation in which the council is going to be afforded the opportunity to start doing some careful planning. But at some time, no is not going to be okay.
Right. No, that's good. Good. What about noise? Do we have the same issues with noise and things like that from heat pump systems? Now that we're allowing it, are we going to see, or have we seen an increase in complaints related to noise from these units?
I have not seen any. I know it's a hot topic as far as concern over heat pump installations, but personally, I haven't seen any complaints. I do strongly recommend, though, that strata corporations, when they draft their heat pump bylaws, that they set out a limit on noise or the maximum decibels, and that's going to change over time as well. So it's possible that when the heat pump is installed, that it's going to be under 50 decibels or something like that. But as it gets older, as the technology gets older, they may become noisier. And it's helpful to kind of try to anticipate that, which is also why the bylaw, in my opinion, should always include a provision that the owner is going to sign an alteration and indemnity agreement. And it's going to require the owner to take it out at some point if the strata council decides it's time to take it out.
Right, just like the EV charging system legislation allows,
Exactly.
right?
Yeah.
And again, maybe mirroring your bylaws based on what has already come down for EV chargers is not such a bad idea because we may see those changes in the future that affect heat pump installations and things.
Yeah. That's right.
Yeah, so always good to be proactive, like you say. Um, what do we got here? So common property will likely be impacted. How can responsibility for maintenance of the alteration to common property be passed on to the owners? And I just maybe a little comment too on future owners of the property. Do you build into your alteration agreements future
Yeah.
owners? Yeah.
So I love that question, and because there's a CRT decision that I have a bee in my bonnet over, and so it's a great opportunity for me to discuss that. So generally speaking, and I learned this in law school. Generally speaking, you can't enforce a contract against a party that didn't sign the contract. So, for example, if I'm the owner and I'm installing my heat pump, I'm going to sign an agreement with the Strata Corporation. I'm going to say I'm going to repair and maintain it. But if I sell to a purchaser, the Strata Corporation can't go to my purchaser and say she agreed to it. You have to agree to it because the purchaser hasn't signed anything with the Strata Corporation. So that's the general philosophy. Now, the way I approach it under my alteration agreements is one, I say in the alteration agreement that the owner won't sell unless the buyer signs an agreement directly with the Strata Corporation. But I also say that the alteration will be removed if the person doesn't sign. So it creates incentive for the person who's purchasing the property, who wants to be cool in the summertime. They're going to sign on to it because they know if they don't sign on to it, it has to be removed. There was a CRT decision recently, and it's Jensen, and it basically skipped over the issue of privity of contract, and it said a purchaser who had knowledge and notice of the alteration agreement is bound by the terms of the agreement. So
Mhm.
I I hate to criticize the CRT. I think in law it was not a correct decision, but it was something that I think should be happening anyway. I think logically it was appropriate, but legally I don't think it could necessarily have been supported.
Okay. We have a question about putting details of maintenance and repair obligations right into the alteration agreements. So is that something that you also have, like very detail on, you must service it 3 times a year or something like that?
Yeah, you can absolutely do that. The details are helpful. The only caution I would make about that is that things change over time. Like when I started practicing in law, we were still using faxes. So
Mhm.
you can't you have to be able to anticipate that things are going to change, and you don't
Right.
want to be so detailed that you're married to this old technology.
Create the obligation without getting into too much detail.
Yeah.
Great. Okay. And let's see, what else have we got here? Altering common property. We have a couple of questions about that. How can an owner get approval to alter or replace a window that's part of common property? And I guess also I've seen where for heat pumps, you would, instead of drilling through a concrete wall with rebar in it, having to get x-rays and all that done, you could actually replace it like a side light in a window that's on a balcony and run the pipe through that way. But again, is part of the alteration agreement and the approval that's required of common property, that's something that's contained within your bylaw that you write for stratas or
Yeah,
already?
I think that the bylaw is always going to say you have to get approval before
Yeah,
altering common property, and it may be that simple. But then the next part is going to say the conditions under which
yeah,
approval will be provided. So I've
right.
seen many strata corporations, for example, say you won't get approval if you're going to be drilling into the envelope, and other
Hmm.
strata corporations will say, well, you can have approval if you're drilling into the envelope if you involve this engineer.
Yeah.
Mhm.
And I guess the one thing too is to remember that even with approval to alter common property, you're not changing its designation. It's still common property and the strata still is an obligation to repair and maintain.
Yes, that's right, and that's why it's so important to have that alteration and indemnity agreement. Um,
Right.
there are so many scenarios in which, for example, I've seen, and it happened in the 80s and the 90s, owners who enclose their balconies, which are common property, and of course the balcony starts leaking, and then the the Stratolot has changed hands 3 or 4 times, and the current owner doesn't want to pay for the
Yeah,
leak, and lo and behold, it's common property, so it's Strata Corporation responsibility.
right. Good question too that just came up, popped up. What about retroactive alterations agreements? So in other words, an owner or a few owners may have been just doing this over the years, and the Strata is now trying to sort of straighten the books out. How do they go about dealing with alterations that have happened, but there's no record or management of them? Can you speak to retroactive agreements?
Yeah, I think that there is an argument if there's an argument to say if this alteration exists on the common property and there's no record of the fact that it was approved and that bylaw was always in place, Strata Corporation has or the owner has altered without approval, they breached the bylaw, and we have the ability to enforce the bylaw. Now, many owners will say, "Well, listen, I just want to sign on to it now. I promise I'm going to take care of it now. You give me my approval. I'm going to agree to sign an agreement." And there we go. I've done that many times. Yeah.
Right. So that's definitely an option. And
Yeah,
in light of saying that strata corporations need to act or strata council should be acting reasonable, that could be a reasonable solution to a dispute that could just go off the rails, right?
for sure. For sure.
Mhm. Okay. Um, here's some technical language. Do your alteration agreements um, should they include boxes for initialization of the parties, or is just a signed agreement the thing to do?
I love that. I love that creativity. I personally don't do it. I do require it to be signed in a PDF form, and I put page numbers on it and whatnot. I personally don't do it, but I like the creativity of asking for it, particularly if it's like maybe if it's the provision that says that we'll remove it if we can't get the purchaser to sign. Maybe you're getting that initialed, but it also means that you might not get the person to sign the agreement in the first
Hmm.
place. So
Hmm.
yeah.
And back to that common property issue, we also have like, does that the same kind of rule apply to limited common property when it comes to an alteration to it? So, you still got to sign the indemnity agreement. You're making an alteration to property. Limited common property is still common property, but um, can you go further with the expectation of an owner when it comes to LCP?
Well, of course, the Strata Property Act enables the Strata Corporation to assign repair responsibilities for LCP to owners. So it's possible that maybe you don't need an alteration agreement when the person is altering their LCP, but my practice is it's always best to have both.
Right. And what about heat pumps that exist on common property? Whose responsibility are they? I know it's a general statement, but
Yeah, I've seen that a number of times, and of course, the CRT has a couple of decisions on this as well. There, my experience has been that there are some developers who are putting air conditioners in or heat pumps in. They're putting them on the roof of the building, and they're servicing various strata lots. So the the mechanisms for the heat pump or the air conditioner are not in the strata lot or even near the strata lot, makes it difficult to argue that the owner is responsible to repair and maintain it when it's on clearly on common property. So it's a
even, yeah,
tricky.
even
Yeah.
when it only services one unit, right?
Yes, that's right.
Yeah.
Yeah.
Okay, good, good. Um, we've got some detailed questions about CSA approvals. Um, I'm not sure if we want to go too deep into that. Do you have anything to say about kind of maybe that's what we want to express here is what kind of information does the Strata Corporation are you going to want them to have? Like, do we want to make sure that it's a CSA approved product? Is that going to be built into your alteration agreement? Things
Well,
like that.
it could be. So I actually worked with one strata corporation on the island about a year ago, or maybe a year and a half ago. They were so proactive, and they had an engineer, a consultant involved. The engineer wrote 5 pages of suggestions as far as the heat pumps, etc. The council really wanted to put all of that in, so I put it in a way that was understandable. It was quite a complicated bylaw, but it worked for the Strata Corporation, and I just did tell them though, you have to keep it updated
Yeah,
because things are going to change. Now, I actually saw a question here that I think is a really interesting one. Do you mind if I just read it out?
go for it. Yeah.
Okay, so it's, can you include a duty to consult neighbors who may be impacted by the pump? So yes, you can. The council can do whatever they want as long as 3/4 of the owners approve it. In my opinion, though, it wouldn't be a wise thing. One, neighbors shouldn't have control over whether a person does an alteration. That's up to the council, and it's the council's duty to act in the best interest of the Strata Corporation. Shouldn't be conferring with neighbors unless it's a Section 71, a significant change in the use or appearance of common property.
Right.
I think that could go very wrong.
Yeah, I've seen that before too, and it was also, trying to advise them to say that, well, the consultation may be required in the bylaws. This isn't veto power that the owner
Right.
has who's being consulted, right? So
Yeah,
they have
that's
to be
right.
very clear, right? Yeah.
In my experience, and you might have seen this as well, Daryl, not everybody in a strata corporation is reasonable.
Well, I'm so glad. That's why we're here. Um, Again, thank you very much. We're at the end of our session. Thank you to Jennifer Neville. If you have any questions, please remember to send them in. Also, this is going to be posted to the YouTube channel along with some slides and Jennifer's article from December. So thank you, Jennifer.
Okay, thank you. Have a nice day, everyone.
Yeah, take care, everyone. Thank you for attending.